Hi guys, welcome back. Thank you so much for being here. So greatly appreciate it. Truly, truly is. Okay, before we get started, let me give you my usual disclaimer that this video is for educational purposes only. Please do not take what I say as fact. Please always do your own research and come to your own conclusions. Next, if you have not liked, subscribed, or commented yet, please consider doing so. It really helps me out and I really appreciate it. Next, this is a really long story. There's a lot to it. There's a lot of research that needs to be done. So, if you see me in a bunch of different outfits looking crazy, it is because this is probably taped over a bunch of different days because there's so much to it, but I figured I'd rather look crazy with a bunch of different outfits in a video than not give you thorough researched material. So there's that. And lastly, guys, give me a chance with this one. If you're one of the ones that click off midway during my videos, it's hurtful. But, and however, give me a chance with this one because I promise you, this is going to blow your mind. I promise you that. Please give me a chance with this one, okay? And with that, let's start, okay? So, before we get into the insanity that is Darrell Brooks playing lawyer, let's go over a little bit of the backstory for context. And most importantly, to acknowledge the 6 innocent victims that lost their lives because of Darrell Brooks. Because before he was playing obnoxious, narcissistic lawyer, he was playing entitled criminal. So, Darrell Brooks has been charged with 16 crimes since 1999, which included 3 felony charges. Shortly before the November 21st, 2021 tragedy, Darrell was locked up for running over his girlfriend, who was also his child's mother, with his SUV. His bail was set at $1,000 cash, which that's another story for another day and another rant that I'll probably get into at some point, right? Because God forbid I don't get into a rant. But he posted his $1,000 bail, and this should have never happened. But the district attorney's office has said that this bond was set inappropriately low and that they are conducting an internal review of this decision to find out how this happened. Because if the bail was set properly, we would not be sitting here talking about what we're about to talk about. And that's always the worst part. All right, so before we get into this narcissistic man-child that is Darrell Brooks, let's talk about the victims because they're honestly and truly what's most important in every single one of these stories. In my eyes anyway, right? Okay, so 79-year-old Virginia Ginny Sorensen was married to her husband David for 56 years. The couple had met at a church gathering. Ginny taught him the French can-can, and the rest is history. She was a mother of 3 and a grandmother of 6. She graduated from the Milwaukee School of Nursing, and she was a registered nurse up until her death. She loved all animals from horses and chickens to cats and dogs. 52-year-old Tamara Durand was the mother of 3 and the grandmother of 1. She had a master's in education and theology, and at the time of her death, she was going to school to obtain a doctorate in theology. She was a chaplain for Zilber Family Hospice and Waukesha Memorial Hospital. She taught for many years at Beaver Dam Elementary, and she was a cheerleading coach. 71-year-old Leanna Owen was the mother of 2 and the grandmother of 3. She met and married a man named Mike, and even though the two would end up divorcing, they remained extremely good friends. At the time of her death, she was working as an apartment manager, which is said to be her favorite job of all time, and she was absolutely beloved by all of her tenants. Okay. Virginia, Leanna, and Tamara were also all part of a group called the Dancing Grannies. The group would go from parade to parade to dance, about 25 parades a year, and the only requirement to be a dancing granny was that you had to be a grandmother. Which is cute, right? So cute. They're probably so cute. I love grandmothers. I don't know why. I love grandmas that are just, I love grandpas too because they're just little and cute and like, oh my God, I just love them. Okay. 81-year-old Wilhelm Haspel was married to his wife Lola, who was a dancing granny, for 61 years. Bill, his parents, and his three brothers fled Cleve, Germany when he was 15 years old. He worked at a steel company and he did carpentry on the side for many years. He was an excellent handyman, and his wife said that he was willing to take on any home project. He was also a very active person, even at 81. He would go to his local YMCA every single day. He loved to hunt, dance, play pickleball, and ride ATVs. 52-year-old bank worker Jane Kulik was married to her husband John. She was the mother of three and the grandmother of three. She wasn't a dancing granny, though. Okay. And last, but certainly not least, 6-year-old Jackson Sparks. Jackson was a third grader at Clarendon Avenue Elementary School and a member of Life Point Church. He loved to play baseball and basketball. He also liked fishing, catching frogs, and playing with his older brother and his dog. Along with this were several dozen people that were injured. Okay. So, what happened? The evening of November 21st, 2021, while so many were enjoying the annual Waukesha Christmas Parade, Darrell Brooks, who should have been behind bars at the time, was having a domestic dispute with his girlfriend and baby mom. After screaming, fighting, and putting hands on her, Darrell jumps into his red Ford Escape and takes off before cops have time to arrive. He heads towards the Christmas parade that was being held on East Main Street. And very soon after, Brooks began barreling through the parade. Word gets out and the pursuit begins. During the pursuit, Darrell drives at a police officer that's standing in the middle of the road. The officer shoots at the SUV 3 times with his service weapon and hits the SUV all 3 times. But not Darrell. So instead of giving himself up, Brooks decides to ditch the car and take off on foot. He begins ringing doorbells and asking multiple people for help.
Hey, I'll call the Uber, and I'm supposed to be waiting for it over here, but I don't know when it's coming. Can you call it for me, please? I'm homeless.
He finally stumbles on the door of a man named Daniel, who buys his story about him being homeless and cold and needing a phone to use to call an Uber. Daniel, who's watching football that evening and has no idea what's going on, invites him in. He lets him sit down on the couch. He lets him use his phone. He makes him a sandwich. The whole time never knowing who was in his living room. Which, this is the part about shit like this, okay? Is because now, if there's somebody that's really in trouble at some point and they go to Daniel's door, Daniel might not be as inclined to help them next time because people like this asshole. It's true. It is absolutely the truth. Because you never know who's at your door. You never truly know if the person at your door is bullshitting you or if the person at your door truly needs your help and will truly appreciate it. And that's the messed up part. These people ruin shit for everybody else.
So he was on my porch for, I don't know exactly, a minute maybe, and he was telling me the interaction, or he was telling me that he needed to use my phone to let his Uber know where to pick him up, and that he was homeless and cold, and he said he didn't have any weapons or anything on him, and he lifted his shirt real quick, and I was like, no, it's okay, you can use my phone, and I let him come inside and warm up. I just tend to believe people, and I'm from a small town, and we had people that need help all the time, because we live right off a highway, so I'm used to, didn't faze me too much. I mean, I was nervous for sure, but I was like, yeah, I can let you use my phone. And he made it sound like the Uber was going to be here just any second, just needed to know where to pick him up. So I said, yeah, you can come and warm up while you wait for the Uber. And I let him sit on the couch right by the window out front. I said, you can look out here waiting for your Uber. And he's on the phone most of the time after that with his mom.
After a little while, Daniel sees police cars driving by his home, and he gets a little spooked. So he asks Brooks to give him back his phone, and Brooks complies. He asks Brooks to leave, and he says Brooks complies.
Yeah, he left when I asked him to. So he was in my house for 8 or 9 minutes. I'm looking around outside, and I see a police car drive by. And then I see another one coming down the street. And so I tell him, I say, hey, we don't get a lot of police traffic on this street, and I'm getting nervous, and this is just too weird of a situation. You're fine to wait for your Uber, but you need to do it outside of my house. And he was a little bit like, oh, no, it's okay, don't worry, man, don't worry. And I said, no, you need to leave. And then he listened and got up, and I've got video footage of that, of me escorting him outside of my house.
And he just leaves and begins to walk off. A short time later, though, Brooks comes back and he's banging on Daniel's door, telling Daniel that he left his ID inside. I don't know if it's true or not. It doesn't matter. So Daniel, who has, wised up at this point, tells him that he's not coming back inside, but that he will look for it. While Daniel's inside looking for his ID, police spot Brooks and they arrest him without incident.
My ID! My ID!
Okay, so let's skip ahead to day one of the trial. Darrell Brooks decides to defend himself, which is his right to do. It's a fucking stupid idea, but nevertheless, it's his right to do it. And so begins the shit show that is the Darrell Brooks trial. Day one, and we're off to a great start, guys. Great start. Ready? The Honorable Jennifer Darrell asked Darrell Brooks to please stop interrupting her or she will be forced to remove him from the courtroom. And this goes on quite a few times. This is not an isolated incident, just so you know. So She continuously tells him to stop interrupting her or she will be forced to put him in a separate courtroom and make him watch the trial virtually. Next, she asks Brooks to please go put on a suit as opposed to his inmate attire, which screams prisoner to the jury. She tries to explain to Brooks the importance of dressing properly, but this happens.
Steps to shield from this jury that you are in custody. Your hands are not shackled. Okay, there are skirts around each one of the tables. I'm aware of the feet shackles. That's yet another interruption. I'm aware of the shackles on your feet, and that's why the skirts are on your table and frankly all of the tables, right? So that it appears to be the same for anyone coming in and viewing. Again, their arrangements have been made for you to appear in street clothes or civilian clothes. I would like you to appear in street clothes, and the reason why, sir, is to reduce or even eliminate even the appearance that you are in custody. And it is your choice, though. Are you willing to go back to your cell and put on your suit?
It is my right to do so or to not do so. And at this point, Your Honor, who doesn't know that I'm in custody?
Mr. Brooks, I've had many trials with individuals who were in custody, and when I've talked to the jurors after the conclusion of the case, they had no idea. The whole point of allowing for street clothing is not only to shield jurors from the fact that you are in custody, but also you being in a suit and a tie or other street clothing, I think also lends to the dignity of the proceedings. This is a trial. Again, it is your choice. Are you willing to go back to your cell and be dressed in the street clothes that you previously appeared in?
With all due respect, I do not agree with that assessment whatsoever. There's no possible way that anybody will not know that I am in custody. I think that's a well-known fact because it's reported on every day in the media. It's shown every day on the news where I am, what jail I'm housed in, and that I'm in custody. It's virtually impossible for anybody to not know that I'm in custody.
Mr. Brooks, did you hear the question that I asked you?
And I respectfully keep the position that I just put on the record.
Mr. Brooks, I will ask you again. Are you willing to go back to your cell or into the jail and put on street clothes?
I do not consent or agree to anything that you just stated, Your Honor.
All right, he did not provide an answer to a very direct question. Let the record be very clear that Mr. Brooks was given multiple opportunities to answer that question. And go back, Mr. Brooks, that's yet another interruption. I will advise you, sir, that at any point in time, if you wish to put street clothes on, I would give you that opportunity to do so. You've already heard it is my preference. You've already heard me advise you regarding the steps that have been taken to shield the fact that you are in custody from the jurors. You refuse to answer my question about whether you would go back to the jail. That's another interruption. So based on his refusal and his choice to come, that's another interruption. Based upon his failure to answer my question directly, I will take that as a non-response, but he came to court here today. That's another interruption. I will take that because he's come to court here today in his jail attire, that is a choice that he has made freely, voluntarily, and intelligently. No one has forced him to come to jail in those clothes. This court is encouraging him not to. He's appeared previously in his street clothes in what I would describe as a very nice suit and tie, but it is his choice to not do that, and we will proceed accordingly.
So while we're on the record, may I challenge the subject matter jurisdiction?
No, you may not, sir. You need to file a motion in order to do that.
So
Mr.
the
Brooks?
motions I filed haven't even been responded to. I gave.
Mr.
a
Brooks, you're
3-day
interrupting me
No,
yet
you
again.
just weren't speaking,
All right,
so I didn't
Mr.
interrupt.
Brooks, you are now going to be removed to the
I
other
don't
courtroom.
consent to that.
I have
I
had
am under
a
duress
dozen or
by
more
having
interruptions.
shock- I
We'll
have
be
shock-
off the record while we
shocks
do
on my
that.
ankle.
Thank you,
I
everyone.
don't agree to a stop. I move for a motion to dismiss for being under duress and being coerced into a contract that I did not consent or agree to. I did not. I have a right to be present for trial.
Appearances are as they were before. I need to make a record that at 8:42 a.m. this court ordered Mr. Brooks be removed from the courtroom due to repeated interruptions and disruption with the court. This, of course, comes on the recent history with Mr. Brooks. On every day that we have been in court since Monday, he has shown a complete and utter disrespect for the simple rules of civility. He has been removed from the courtroom multiple times. This morning alone, he started interrupting this court within a minute of the court calling the case. I should also make a record at the moment he is muted because of the way that he was removed from the courtroom and his conduct since. I have been given just a bit of information about it. I will advise everyone that I have required that the Sheriff's Department file a written report with the court regarding Mr. Brooks's conduct. I'm told that he would not sit down while in this courtroom in order to have the shackles removed so that he could be taken to the other courtroom, that he was resisting, that at one point he took off a shoe and it appeared to the deputies that he was going to throw the shoe. You can see that he is seated with his back to the court or to the camera. He took his shirt off as well. I'm also told that he is threatening to throw and break items. I want to give him headphones since he has claimed in the past to be hard of hearing in one ear. But given his statement that he would throw and break things, unless he can pledge to this court that he will not do that, I'm not going to provide that information. I will advise that the audio in that courtroom should be turned up.
Judge Darrell is forced to remove Brooks from the courtroom for interruptions for the first of many times. The best part of this whole thing is that she was trying to help him and coach him. He doesn't have to be in a suit. He doesn't have to be in a suit. But it would absolutely be in his best interest to do so. Instead, Brooks decides to take off his shirt. Yep. Yeah. He decides to take it off. That's child's play. I promise you, it's child's play. It's no fun. So the judge excuses the jurors so that the courtroom can handle a few issues that have arisen before the trial gets underway. Okay. First up, Darrell Brooks claims that one of the jurors flipped him off.
Go ahead, sir.
I noticed that one of the jurors, the lady in the black that's closest to the screen in that corner chair over there, I recognize her from my initial appearance. She flipped me off coming in to my initial appearance and coming out. I know it's her for a fact. I seen her about like how I'm looking at you right now, so I know for a fact that's her. I don't want that to end up being an issue. Is this some type of way that could be addressed by Your Honor?
Mr. Brooks, you had an opportunity to exercise preemptory strikes and even to question jurors about that. You chose not to. So at this point, any issue you have with that juror is waived.
Okay, you do remember that I was not present in the courtroom. I couldn't see. All I can see from that courtroom in there is just you, Your Honor, and the prosecution's table. I can't even see the bailiffs. So it was no way for me to even see who the jury was. Obviously, I wouldn't know them by name. If I would have been able to see the jurors, I would have immediately addressed that.
I will make this one indulgence. I'll have the civilian bailiff ask that juror if she was in attendance at your initial appearance out of an abundance of caution. These are jurors, though, who with the jury questionnaires were also asked what knowledge they had about proceedings they watched or even attended. And no one, to my knowledge, has disclosed anything like that, but out of an abundance of caution, we will ask that juror if she was in attendance at your initial appearance. So for now, that's how I'll address it. I'll advise you of what her answer is.
Next, you're going to keep hearing him say, I do not consent to be called by that name. Throughout this whole thing, he says it so many times. What Darrell Brooks is referring to is that it was his claim that he could not have been the person that did the attack because he doesn't know anybody by that name. The name Darrell Brooks. That's not his name, and he doesn't know anybody by that name. So there's no way that he could have been the person responsible for this. This is his first offense. Even though several witnesses that know him personally, including his girlfriend and baby mama, referred to him as Darrell Brooks during testimony. Okay. Before I forget, let me just say this also. This judge is the definition of kindness and patience. I'm not kidding you guys. I will never know how she does it. I will never know how she kept her cool during this trial. I have much respect for her because if it was me, I would have told him to go his mother a long time ago. So I have a lot of respect for her. She's a class act. On the other hand, I would be lying if I didn't say that there were so many times during this where I was just like, oh my God, where's Judge Judy? I need Judge Judy up in here because she was just being too patient and too polite for my blood. Like, I wanted to see more. It's terrible, I know. But all kidding aside, she's a class act. She truly, truly was. Okay. I also say this because there were questions she presented to Brooks that were so simple. For instance, okay, she asks him if he would be willing to conduct himself appropriately so that she can allow him to come back into the courtroom for testimony of the first two witnesses. She even coaches him on how to properly object to statements made by the prosecution. So, along with everything else that has happened thus far, we're on day one. Now she's trying her best to get him back into the courtroom to be physically be part of the trial in the room, not virtually, and she's coaching him. I don't know if I could do that. I don't know if I would be doing that. I truly don't know. She's a better woman than I am, I think.
Behind that is that you give me just a little bit of information so that I can either make a determination or, if appropriate, send the jury back out so that I can then hear arguments from the parties. Some objections really are one word, hearsay, maybe three words, calls for speculation, things of that nature. So if you're willing to abide by that procedure, then you can come back to this courtroom.
I can't really definitively give an answer right now to that.
So you're not willing to follow the rules of courtesy and decorum and procedure and evidence?
That's not what I said.
That's why I'm asking the clarification question, sir.
I was clear in what I said. I don't think I can make that determination right now.
Let me ask it this way, sir. You may reclaim your right to be present if you are willing to conduct yourself consistently with the decorum and respect inherent in the concepts of courts and judicial proceedings. Are you able to do that, sir?
I thought I have.
Sir, it's I think, a fairly simple question. I'm asking you if you are willing to conduct yourself appropriately. I'll shorten it to that. Are you willing to conduct yourself appropriately, sir?
I have to the best of my ability.
Sir, please answer my question directly. Are you willing to conduct yourself appropriately?
I have conducted myself appropriately.
I'm not asking about your past behavior. I'm asking if you're willing from this point forward, for the purposes of the testimony of two witnesses, to conduct yourself appropriately.
I have.
That's not my question. That's not the answer I'm looking for. I'm not asking if you have. I'm asking if you're willing going forward to conduct yourself appropriately during the questioning of these two witnesses. Yes or no?
I'm going to end up getting put back over here eventually if I come over there.
Mr. Brooks, I'm further advising you, I'm looking for a direct answer of yes or no, and that your failure to give me a yes or no answer will be considered by this court to be non-responsive. So let me ask you the question one more time. Are you willing to conduct yourself appropriately during the questioning of these two witnesses?
To be 100% honest, I cannot answer that.
All right, then based on that answer, which is non-responsive to the question that I asked, he has not given me a pledge or indication of a willingness to conduct himself appropriately going forward, and based on that, he'll remain where he is. You will remain unmuted, and so if you have an objection, you can lodge that objection within accordance or according to the rules of evidence, sir.
Next, you're going to keep hearing him say, I do not consent to being... Next, you're going to keep hearing him say, I do not consent to be called by that name. Throughout this whole thing, he says it so many times. What Darrell Brooks is referring to is that it was his claim that he could not have been the person that did the attack because he doesn't know anybody by that name. The name Darrell Brooks. That's not his name, and he doesn't know anybody by that name. So there's no way that he could have been the person responsible for this. This is his first offense. Even though several witnesses that know him personally, including his girlfriend and baby mama, referred to him as Darrell Brooks during testimony. Okay. Before I forget, let me just say this also. This judge is the definition of kindness and patience. I'm not kidding you guys. I will never know how she does it. I will never know how she kept her cool during this trial. I have much respect for her because if it was me, I would have told him to go his mother a long time ago. So I have a lot of respect for her. She's a class act. On the other hand, I would be lying if I didn't say that there were so many times during this where I was just like, oh my God, where's Judge Judy? I need Judge Judy up in here, because she was just being too patient and too polite for my blood. Like, I wanted to see more. It's terrible, I know. But all kidding aside, she's a class act. She truly, truly was. Okay. I also say this because there were questions she presented to Brooks that were so simple. For instance, okay, she asks him if he would be willing to conduct himself appropriately so that she can allow him to come back into the courtroom for testimony of the first two witnesses. She even coaches him on how to properly object to statements made by the prosecution. So, along with everything else that has happened thus far, we're on day one. Now she's trying her best to get him back into the courtroom to physically be part of the trial in the room, not virtually, and she's coaching him. I don't know if I could do that. I don't know if I would be doing that. I truly don't know. She's a better woman than I am, I think. Next, you're going to keep hearing him say, I do not consent to being called by that name throughout this entire trial. Even though several witnesses who know him personally, including his ex-girlfriend and the mother of his child, refer to him as Darrell Brooks during testimony. Darrell Brooks identifies as a sovereign citizen, meaning he does not believe that the government has authority over him.
You've been asked here today several questions from Mr. Brooks about what you saw as the vehicle passed you. Is that correct?
Objection. I do not consent to being called that name, and I do not know the person that you refer to.
Objection is noted. It's overruled.
So about how far was it from where you saw the red SUV with Mr. Brooks driving to where this video was taken, and this is a screenshot from that video, correct?
Objection. I do not consent to being called that name, and I do not know the individual by who you refer to. Objection. I do not consent to being called he.
Sure. For the record, Mr. Brooks.
Objection. Objection. I do not consent to being called that name, Your Honor, nor do I identify by that name.
This witness identified the defendant, Darrell Brooks, as a person driving the car.
May my objection be noted that I do not identify by that name, nor do I know anybody by that name. I don't consent to being called that name.
No need to address the request for grounds by Mr. Brooks due to this.
Objection. I do not consent to or agree to being called that name, Your Honor, for the record. I don't consent to being called by the name that this court chooses to identify me by. I want to state for the record that I'm here as a third-party intervener on special appearance on behalf of my client. Can that be noted for the record?
It was noted this morning.
May it be noted again for the record so that we can keep the record clear and accurate.
Mr. Brooks, just make your statements. What do you want to advise the court today?
I want to first state again for the record that I do not identify by that name, nor do I consent to being called that name. That name again, and I don't consent to it again for the record.
Noted.
There have been the subpoena sheet that would have had your name and any number of different.
What do you mean my name? What are you referring to?
I believe it would have said Darrell Brooks on it.
Are you aware that I don't identify by that name?
And just to clarify again, who was the driver?
The defendant.
Darrell Brooks?
Darrell Brooks.
Objection. I don't consent to being called that name, and
Mr. Brooks, I'm sorry.
I don't consent to being called that name.
All right. Sir, Mr. Brooks, do you have any questions for this witness?
Yes, I do, and I object to being called that name for the record.
Was a decision made to speak with Mr. Brooks the following day?
Objection. I don't consent to being called that name, leading the witness.
You had approximately another couple minutes of conversations with Mr. Brooks before you called it a night. What was the vibe that you got from him during those couple minutes?
Objection. I don't consent to being called that name, leading the witness.
Did Mr. Brooks at all talk to you about the loitering in terms of what the focus of your investigation was that night?
Objection. I don't consent to being called that name, leading the witness.
Overruled. The witness may answer.
Sean Backler. Sean Backler is called to testify. He's one of the witnesses that ends up coming face to face with Darrell Brooks after he ditches his SUV. Sean was doing work outside when he spotted Brooks on his property. The pair have a heated discussion, and it's no different during testimony.
And you did talk to an officer that night?
I talked to an officer on the phone. I did not talk to an officer that night. I mean, on the phone I did, but not in person.
So it was a conversation on the non-emergency line. Would that be fair to say?
It was on the non-emergency line. I actually confirmed it after I called to make sure I was on the non-emergency line.
Do you recall the description that you gave at that time?
I do. Well, my best of my knowledge was that you were either black, Latino,
Who's you?
Or mixed.
Who is you?
Hold on, you have to let him answer the question first before you interrupt him with another one. Go ahead with the description you provided that night.
I said that the individual was either black, mixed, or Latino.
So it would be fair to say you didn't know at the time?
I was giving a general description.
So it would be fair to say that you weren't sure?
I was positive it was you.
Who is you?
You. I'm looking at you.
And how did you come to that conclusion, the you conclusion?
I'm looking at you.
How did you come to that conclusion? Did you?
What conclusion? Can you restate the question?
You're saying that you gave a description on the non-emergency phone line, correct?
It was on a non-emergency line.
So it would be fair to say at that time you had no name or knowledge of who the person was in your backyard. Would that be fair to say?
I had no idea who you were.
And so how can you say how can you say you then if you had no idea?
I'm looking at you. You are the guy.
And how did you come to that conclusion?
You and I were standing in the same yard looking at each other.
So is it possible you saw something on the news?
No, I had no idea who you were.
Interesting. Do you recall giving a description of approximately 5'9" and 160 pounds?
Yeah, something like that.
Something like that, or would that be accurate?
I didn't have a tape measure out. It was just a guesstimate.
Would it be fair to say that since you keep identifying me as you, would it be fair to say that I'm not 5'9" nor 160 pounds?
You have your shoes on or off right now?
Would it be fair to say that I'm not 5'9", 160 pounds?
If you take your shoes off and step out of them.
Does it look like I'm 5'9"?
Sit your ass down.
I don't know, we were a lot closer.
Does it look like I'm 160 pounds?
Objection.
Grounds.
It's irrelevant as to his appearance today, just like his hair isn't in dreadlocks today.
Sustained.
Objection.
Next question.
Grounds for the sustain.
Next question, please.
Within the first hour, Darrell Brooks has already fought with the judge about subject matter jurisdiction. Just on this day. That's not all the other days that he did. Okay, so to the best of my knowledge, I'm understanding this as if a court does not have jurisdiction, one of the parties can have the case dismissed. So I'm guessing this is a tactic on Darrell's part to get the case thrown out.
Bring the jury up.
And we have yet to address subject matter jurisdiction, Your Honor. I still haven't been shown any verified proof that
All rise.
this court has subject matter jurisdiction. And at this point, may I request an affidavit that you, Your Honor, have no bias, no conflict of interest, and no interest in the outcome of this case?
Mr. Brooks, the jury's coming out. We'll address your legal issues later, if I deem them appropriate.
Judge, do you hold the full
Mr.
judicial
Brooks,
power of the
please,
state, or is this
please.
the military
All right, can
power?
you please take the jury out? Thank you.
Do you hold the full
Mr. Brooks, just
jurisdiction?
wait till the jury's out, please. I ask that you show that respect.
I will.
Thank you. Everyone else can be, you all can be seated. Mr. Brooks, just make your statements. What do you want to advise the court today?
I want to first state again for the record that I do not identify by that name, nor do I consent to being called that name. Your Honor, with all respect, I'm merely asking you, do you have the full judicial power of the state, or is this military power?
I'm sorry? I don't understand what you're asking me, sir.
I'm asking,
And on what legal basis are you making that request?
I'm asking, for the record, is this a common law court or an admiralty court? What are we in here? And I'm requesting an affidavit that you, Your Honor, have no bias, no conflict of interest, or no interest in the outcome of this case. And the reason why I want to state this clearly for the record, mainly is because of the bias that's been shown. I have not been getting any certified copies of any requests that I've made, which I was told by this court to address inmate communication forms for anything that I may need. I've done that. I've complied with that. Every time I've needed something of the court pertaining to documents, I've done it the way the court has asked me. And I've always stated that I wanted everything to be certified. I have yet to even get that. My court docket sheet was not a certified copy. When I asked Your Honor of your oath of office, I asked for that to be certified. You stated for the record that you would not give me a certified copy of your oath of office, which you are required to show if I ask for it. I've brought up my Sixth Amendment constitutional right that has been pretty much discarded, and that is based on the fact that I have the right to face my accuser, which would be the plaintiff, state of Wisconsin, in this matter. They have yet to show that a claim is I mean, a living human being can only make a claim. An entity cannot make a claim. I've requested for the complaint to be provided. The complaint from November 23 of 2021. The amended complaint from November 29th of 2021. The second amended complaint.
Along with this, he continuously asks the judge for her certified credentials and even goes as far as to bring a copy of her sworn oath to the courtroom. Again, it's in my opinion that this is another tactic to stall, get the case thrown out, and or put doubt in the jury's mind about the integrity of the court, the judge, and the prosecution. While interviewing a witness, Darrell Brooks literally begins to throw a tantrum like a 2-year-old over the fact that his objections are continuously getting overruled and the state's objections are continuously getting sustained. I don't for 1 second believe that the reason for this is even remotely prejudice. I really think the reason for this is that Darrell Brooks doesn't have the slightest clue what the hell he's doing up there, which would go back to the point of, yeah, you have a right to defend yourself, but it's a dumb ass idea. Don't do it. It's a dumb idea. And that's probably why he keeps getting overruled.
If you weren't here testifying, that you would have been on duty today? Is it fair to ask that or say that?
Not have been at work today.
So, did you feel the testimony that you would be given at trial today warranted you to be in uniform?
Objection, relevance, Your Honor.
Sustained. You do not need to answer that, sir. Next question, Mr. Brooks.
You said you've been in duty for 18 years, correct?
Yes.
In any of those 18 years, have you ever come across or had any interaction with the plaintiff in this matter?
Objection, vague.
Sustained. You do not need to answer that, sir. Next question, Mr. Brooks.
How long have you known the plaintiff?
Objection, vague and irrelevant.
Sustained. You do not need to answer that, sir. Next question, Mr. Brooks.
Do you see the plaintiff in court today?
Objection, vague and irrelevant.
Sustained. Next question.
Do you have any knowledge of the plaintiff?
Objection.
Sustained.
Have you ever even seen the plaintiff in this matter?
Same objection.
Sustained.
Good morning, Detective Blue.
Good morning.
You've been in law enforcement for over 20 years. Would that be fair to say?
Correct.
At any time during your over 20 years of service, have you ever had any interaction with the plaintiff in this matter?
Objection.
Sustained.
Can you state for the record if the plaintiff is in court today?
Objection.
Sustained.
Have you ever seen the plaintiff?
Objection.
Sustained.
Do you even know of the plaintiff?
Objection.
Sustained.
Ever spoken to the plaintiff?
Objection.
On what grounds?
Sustained.
On what grounds?
It's sustained. Next question.
May I ask what grounds, Your Honor?
Mr. Brooks, do you have another question?
I do. I was just trying to follow the rules that you set by saying that an objection has to have a basis. So
Unless it's self-evident to the court. It's sustained. Next question.
The detective that interviewed Ms. Patterson?
Objection. Asked and answered.
Sustained.
To the best of your knowledge, were you the only one that interviewed Ms. Patterson?
Same objection.
Sustained.
At any time, did you learn anything about the alleged incidents that Ms. Patterson claimed from any other law enforcement?
Objection. Same reason.
Sustained.
Do you know if there might have been any video from the alleged incident on November 20th?
Same objection.
Sustained.
Grounds?
It's not relevant.
May I ask how is it not
Next
relevant?
question. There's not a charge related to the 20th, sir. It's not relevant. I've given you leeway to ask questions at this point under 90611. Move on.
Just so I'm clear, you have never had any interaction with the plaintiff.
Objection.
Sustained.
You've never seen the plaintiff.
Objection.
Sustained.
Never spoken to the plaintiff.
Objection.
Sustained.
Never seen. Do you see the plaintiff in court today?
Objection.
Sustained.
Do you know if there is a plaintiff in this matter?
Objection.
Sustained.
Have you had any prior knowledge of the plaintiff in this matter?
Objection.
Sustained.
Oh my God!
Would it be fair to say that you do not know of any plaintiff in this matter?
Objection.
Sustained.
On grounds? What grounds?
Under 906.11, I'm declaring the cross-examination now closed. Do you have any redirect for this witness?
Are you a party to this case in any way?
I don't understand the question.
Are you a party to this case?
I don't understand the question.
Have you filed a claim in regards to this case?
I have not.
Have you read the complaint in this case?
I've read the complaint.
Do you recall who the complaint was brought by?
The complaint is brought by the state of Wisconsin, represented by the Waukesha County District Attorney's Office, District Attorney Sue Opper.
So the state of Wisconsin then would be the plaintiff in this matter then, correct?
That is correct, the state of Wisconsin.
Do you see the state of Wisconsin present in the courtroom right now?
Yes, I do. They are represented at the prosecution table by District Attorney Sue Opper, Deputy District Attorney Leslie Basie, and Assistant District Attorney Zach Witchow.
You said represented.
Yes, sir.
Do you see the plaintiff?
The plaintiff is an entity. They are represented by the District Attorney's Office.
So the plaintiff is an entity?
Correct.
To the best of your knowledge, is an entity a human being?
An entity is an entity. It is not a human being.
To the best of your knowledge, being in law enforcement for as long as you have, would it be fair to say that an entity, which is not a human being, living person, can bring a claim against anyone?
I believe they...
Object, Your Honor, to the
Grounds.
relevance.
Grounds.
Hold on, let her get her objection out, okay?
I mean, I've tried to be patient, but these questions really have no bearing on this.
The objection is sustained on relevance grounds. Next question.
Have you ever had any interaction with the plaintiff in this matter?
Objection, irrelevant.
Grounds.
Sustained.
How long have you known the plaintiff in this matter?
Objection.
Grounds.
Let her get her objection out, Mr. Brooks. It's sustained on relevance grounds.
Well, I do respect, Your Honor. I think that those are valid questions to the matter.
Mr. Brooks, they've been sustained. Next question.
Would it be fair to say that if you weren't here to testify this morning, you would be on duty?
No, I would not be.
So this would be an off day?
I'm currently on vacation, yes.
Do you normally wear your uniform on vacation?
Objection, argumentative.
Grounds.
He may answer.
Only if I have something related to police activity or duty.
Do you feel that it was necessary to wear your uniform in court today?
Objection,
Grounds.
argumentative.
Sustained. Next question.
Are you a party to this matter in any way?
Objection,
Grounds.
irrelevant.
Grounds.
Sustained. It's not relevant.
Do you have a claim in this matter?
Objection, irrelevant.
Grounds.
Sustained.
Have you read the complaint in this matter?
Objection,
Grounds.
irrelevant.
Not relevant. Sustained.
Do you know who the plaintiff is in this matter?
Objection, irrelevant.
Grounds.
Sustained.
Can you testify on who called you to testify, who subpoenaed you to testify here this morning?
I believe it was the state of Wisconsin.
So the state of Wisconsin would be the plaintiff in this matter, to your knowledge?
Objection, Your Honor.
Grounds.
This question is irrelevant.
Grounds.
It's not relevant, sir. Sustained. Next
I think
question.
it holds relevant. Who called him to testify?
He already answered.
So, you've had interactions with the state of Wisconsin?
Objection.
Grounds.
Irrelevant and vague.
Grounds.
Sustained.
Can you testify if the state of Wisconsin is a living human being or an entity?
Objection.
Grounds.
Irrelevant.
Sustained.
Don't have a claim in this matter, correct?
Objection. Irrelevant.
Grounds.
Sustained.
You are aware that all police departments are funded by the state of Wisconsin, are you not?
Objection. Irrelevant.
Grounds.
Sustained.
And inaccurate.
Grounds.
Sustained.
If that's an inaccurate statement, then who pays you?
Objection to
Grounds.
relevance.
Overruled. He may answer. I assume you mean who pays him his salary.
Correct.
He may answer.
Be the city of Waukesha.
Is the city of Waukesha in the state of Wisconsin?
Yes.
Is the city of Waukesha the plaintiff in this case?
No.
How long have you known the plaintiff in this case?
Objection.
Grounds.
Irrelevant.
Grounds.
Sustained. Next question.
So to the best of your knowledge, you've never even had any interaction with the plaintiff in this matter?
Objection.
Grounds.
Irrelevant.
Sustained. Mr. Brooks, under 906.11, if you need to move on to a new topic of cross-exam, otherwise I will declare the cross-exam opportunity closed.
At any time when the vehicle passed you, did you hear the vehicle honk?
Objection. Asked and answered.
Sustained.
The yelling and arguing with the judge becomes so bad that she's forced to have Brooks removed from the courtroom yet again.
Objection. I don't consent to being called that name.
Noted. Overruled.
Yes, I would.
Please do that, sir.
Objection.
Overruled.
Grounds for the overrule.
The witness may answer.
Grounds for the overrule.
Go ahead, sir.
The address for the pieces of mail that I recovered was 4014 North 19th Street, Milwaukee, Wisconsin, 53209.
Thank you.
Objection. That should be strike. When he asked the question, he said he didn't recall. So how can you force somebody to recall?
The witness's recollection was refreshed through the use of his report, which he indicated he documented the address. Your objection is noted. It's overruled. The answer will stand. Go ahead. Next question, please.
Yes, and actually, if I could back up 1 minute and ask Ms. Gussie to put back up 117. Got to ask a question about 117.
Go ahead.
And if we could display it,
You can do
please,
what y'all
Madam
wanna
Clerk.
Nobody got to answer no questions.
Mr. Brooks, please refrain from interrupting. You'll have an opportunity to ask
I
your
have an
questions
objection
on
of
cross.
how stuff got to the table without my knowledge. That should be known. That should at least be noted for the record.
It was
I wouldn't
noted
be.
for-
I wouldn't be able to do that.
Your objection's noted. It's overruled. Go ahead, Attorney Opera.
So that needs to stop happening.
In
It needs
addition
be
to
fair.
that,
All right, I'm going to excuse the jury. All right, for the jury.
Can't keep doing stuff without. It should be a fair trial. That's my right. So then you're not holding me in contempt.
Do not interrupt me again or you will go to the other courtroom.
Under what lawful law?
All right, he's interrupted me once again. We're going to clear the courtroom. He's being disrespectful. I'll make a record once he moves. Unless you can promise me right now that you let me make my record without you interrupting me, sir.
You gonna make your record? You can make your record.
Then please don't interrupt me.
Don't hold me in contempt.
I've never said any such thing.
Removing me from the courtroom, Your Honor, is essentially holding me in contempt.
All right, no, you're forfeiting your right to be present under Illinois versus Allen.
I didn't forfeit anything.
I'm going to start talking, and if he interrupts, then I will close this courtroom, and he will be taken to the next courtroom. Mr. Brooks, you are well aware that the court made some pretrial rulings related to whether there would be, they can stay in, I haven't closed it yet, he's not interrupting me, whether the parties could approach the witness stand. And I did that because you're in custody and I'm not going to allow you to approach the witness stand while in custody. That is why various precautions have taken place to limit, frankly, that from happening. Throughout this trial, there was one instance at the very beginning of the case where I allowed the state to approach a witness. I corrected that. That hasn't happened since. We've had bailiffs take items up to the witness stand, or the items have been given to the witnesses, or they've been placed on the witness stand. That's proper. There is nothing wrong about that. Nobody's trying to pull a fast one over you. No one is doing something that's not permitted by this court, or frankly under the rules of decorum and courtesy or the presentation of evidence in this case. Frankly, from my perspective, sir, your attempts and your comments are to try to dig in at this jury and to somehow create doubt about the presentation of this case or the fairness of these proceedings without the party, meaning the state, having an opportunity to refute, explain, or correct it. I've taken the jury out at this point to admonish you that any further mumbling under your breath or not recognizing when I uphold or sustain an objection, that I will take as a disrupting interruption meant to disrupt the proceedings. I'm not holding you in contempt. I'm well aware that that's one of my options. I choose not to do it for the reasons that I've stated on the record previously. All right, you can forfeit your right to be present at any point in time during this trial by your conduct. These constant mumbling and interruptions during the proceedings. I haven't made a record of them today, but I will now. Started at 9:01, then there was 5 at 9:02, 3 at 9:03, 4 at 9:04, 1 at 9:05, 2 at 9:05, 1 at 9:06, 3 at 9:08, again at 9:17, 9:27, 10:31, 1:05. There was talking over by you at 2:03, 5 interruptions at 2:14, 2:15, 2:17, at 2:19, audible muttering, 2:31, 2:33, what I would describe as inappropriate, like muttering under your breath, 2:35. At 3:06, there was a hilarious comment. At 3:11, there was what I would describe as arguing about the muttering and the irony of it all. At 3:12, there were 4 interruptions. At 3:37, more 4:09, 4:10, more mumbling. At 4:11, twice, and at 4:12, 9 different times. So I think I've made an ample record of the disruptions today. I've been abundantly patient with you. I've, again, as I stated earlier, I've even limited how I tell these things to the jury about how to disregard, and I simply say the jury is to disregard comments and statements made by the parties or the lawyers, as those are not evidence. So I'm warning you, do not interrupt again. If this jury comes back, or when they come back and you do that, then you will be removed and you will forfeit your right to be present for the examination of this witness. Let's bring the jury back in.
Well, you might as well remove me then, because what you're doing is not fair. I can't even rebut what you're saying. I didn't interrupt you. I let you make your incorrect record.
Mr. Brooks, I'm bringing the jury out and we're continuing. We're going to get through these witnesses. Okay?
And I'm not stopping you from doing that.
Through your behavior, you're not going to delay these proceedings today.
I'm not trying to delay the proceedings, so I wish you would stop being incorrect on the record and saying what I'm trying to do if you don't know that. You don't know what I'm trying to do.
I'm bringing the jury out. I'm not going to argue with you.
Then don't. Because I'm not arguing with you either. I'm stating facts.
You're raising your voice. It's
because I'm tired of you always making a record.
At me.
You're making a record of me trying to look bad. I know what you're trying to do. It's not going to work.
I'm making a record of what's accurately.
You're making a record of incorrect statements. That's what you're doing. You're not making a record of not being.
I'm advising you to be quiet because the jury's coming back out.
You're advising me to be quiet? Is you telling me to be
advising
quiet?
you to be respectful when the
Are
jury
you
comes
telling
out.
me to be quiet, or are you asking me?
I'm asking you and advising
Okay.
you.
Thank you for correcting that, because don't nobody tell me what to do. I don't tell nobody else what to do.
I'd appreciate
We're all
if you
we're
lower
all
your tone
adults
of
in here.
voice
I've
and
never
not yell
told
at
you
me,
to do
sir.
anything at all.
Sir, I'd appreciate if your tone of voice would change.
I would appreciate if you would ask me. I'm a grown man with grown kids. Ain't nobody gonna talk to me like that. Nobody.
I love when he makes statements such as, I'm not going to let anyone tell me what to do. I'm a grown man with grown children. Nobody's going to tell me what to do. I love that. You want to know why I love that? My dude, I would get real used to people telling you what to do real fast. Because you're going to be on Wisconsin State schedule for the rest of your life. And it's going to suck. And if you don't get used to it, it's going to be a really, really long life. They're basically going to tell you when to eat, sleep, shit, and shower till the day you die. So get used to it, my dude. I'm just saying.
I don't have a problem with doing what you ask me to do, not tell me. Just like when I asked you about subject matter jurisdiction that you have yet to prove on the record. But somehow I'm being intentionally disruptive. Come on, man. Stop. Just stop it.
Jury's coming out.
All rise for the jury.
Not gonna work.
He becomes so angry over this exchange with the judge that he begins giving her the death stare. Like the death stare. I'm not kidding you. In truth, I was scared for her.
Thank you, everyone. Please be seated. Statement continue its examination of this witness. I believe we're on Exhibit 117.
Yes, we have 117. Madam Clerk, would you please turn the display back on? Mr. Johnson, were there other items on the front passenger seat besides the blue winter hat?
Objection leading.
Overruled. The witness may answer.
I do recall a cell phone being present on that front passenger seat.
Do you remember what kind of cell phone?
An iPhone.
I also see some items that look like maybe headphones or charging cable, something like that. Do you see that, sir?
Objection leading.
Overruled. Foundational. The witness may answer. The exhibits have previously been received.
Objection speculative.
Overruled.
I do see that.
Do you remember something like that on the front passenger seat?
Yes.
Okay. And how about on the floorboard of the front passenger seat? Is there an item there, sir?
Objection leading.
Overruled. You may answer.
Yes.
What do you remember that item was?
A TV.
Okay. And to the left of the TV, the white colored object?
I don't recall what that is.
Okay. But this is the exact way the passenger seat looked when you recovered the vehicle, correct?
That's correct.
Okay. Now if we could please go to Exhibit 116 and put up for the witness only. Sir, do you see?
Midway through day 11, Darrell Brooks is finally ready to give his opening statement.
There's only truly been one side told of this story. And I've sat back and watched. You won't hear me try to argue facts. The fact is, this incident was tragic. Very tragic. That's not lost on me. Facts are that there's still a lot of people healing. A lot of families healing. On both sides. But I'm confident that the evidence will show that this incident was not planned. This incident was not intentional. And this incident was never even thought about. In reference to what I stated earlier, it's easy to forget the other side of the coin.
What?
There's been a lot of suffering involved in this incident. A lot. Even the alleged defendant's family as well. There's been a lot of suffering. This has been a long process for everybody. And what I believe is when it's time for you to make your decision, I believe that, and I pray that it's the right decision. That all the factors are weighed. There's been a lot of words thrown out there about the alleged. A lot of speculation, a lot of ridicule. Words like demon. Words like monster. You see me for who I am. No mask for who I am. The power is in your hands. All of you, to determine for yourselves what truth is. Thank you.
Everything that guy just said is bullshit. Thank you.
All right, thank you. Be seated. Mr. Brooks, under 90611, I do have the authority and just my inherent authority over this case to require you to call the next available witness. You, in my opinion, were not entirely cooperative yesterday with the process, and so I told you that 3 witnesses would come in at 8:30, 2 would come in at 10:30, 2 would come in at 1:30, 2 would come in at 3:30, and then if there were any left, I wasn't sure if there were or not, would come in at 4.
You also didn't provide me with that list.
You were advised on the record,
But
sir.
you didn't provide it to me.
Sir, you chose not to write down. So that's on you, not me.
Nah, that's
So
no. You
here's
can't.
the
That's
thing.
a rush to
Erica
judgment.
Patterson is here, so I'm advising you that she will be the next witness that you call if you so choose. If you choose not to call her right now, then I'm releasing her from the subpoena because we have almost 45 minutes until 10:30, just slightly under that. And there's no reason for you not to call her. She's on your list. She was on the listing as I understand it, with the groupings of 3, Tuesday
That you
morning,
understand it.
Tuesday afternoon,
Did you
Wednesday
receive it?
morning, Wednesday afternoon, and so on and so forth. That's the order. I told you very specifically I'm not going to have everyone come in at one time because that's not efficient, that's not effective, and it's not courteous to them. People have families, people have jobs and other responsibilities, and we're trying to be mindful of all of that as well while having the state assist you in getting these people here. So I'm advising you that if you don't call her right now, you will forfeit your right to call her.
Is that lawful law?
Sir, I believe I have the authority to do that. She's here. She's ready to go.
I'm just
She's
asking
your
the question.
witness.
I'm just asking the question. Is that lawful law?
I have the authority under 90611 and other rules and the inherent authority of this court to control the order and mode of interrogation
Your Honor,
of
why
witnesses.
is it always so hard to just say yes or no?
Yes,
Is it lawful
I have
law?
the authority, sir.
I'm not disputing that.
You just
I'm not
disputed
disputing.
that.
No, I asked the question: is it lawful law?
Sir, I've told you what I believe my authority is. Okay,
You
if
told
you don't
me
want
what
to
you-
recognize it,
you
that's
told
fine.
me
You
your
want to
authority.
object and note it, that's
You told me
fine.
your
Your
authority.
objection is noted
I'm not
on the
debating
record.
your authority. I'm not.
That should address that. I'll have the jury brought back in, and you should be prepared if you choose to call Ms. Patterson. This is your opportunity to do it.
At the same time, though, that's still a rush to judgment, Your Honor. You can't. I shouldn't be forced to call people in the order that I'm being told to when these are my witnesses.
You did not want to provide us with the order, and I respected that, Mr. Brooks.
But I said that.
And
from the
so
beginning.
then I asked
Your
you
Honor,
to put
with
him
all
in
respect,
blocks.
did I not inform Your Honor in the court that I would not give a specific order? I stated that numerous times.
And Mr. Brooks,
Numerous
I
times.
have authority to tell you otherwise. You
I
may
did.
not like it. You may
I did.
disagree with it.
It's not
You
about
have
that.
been-
It's about the rush
you
to
have not
judgment,
been
Your Honor.
cooperating with this process. The
There's
state
nothing
has
to cooperate
graciously
with.
agreed to assist you given your custodial status.
Okay, and I never asked them to
frankly,
do
any
that.
attorney in this
I
situation
never asked them to do that, Your Honor.
would give us the order.
Did I not? Did I ask them to do that? I did not ask them to do that. They
No,
volunteered.
They offered.
So at the end of the day,
but we expect
if
your
they didn't want to do
cooperation in
it,
that.
yeah, but that wasn't one of the stipulations when they offered to do it, Your Honor. Let's
No, common courtesy is the stipulation.
okay,
sir.
but it
And-
wasn't
and here's the
stipulated
thing.
to, so I didn't have.
You are well advised of how this process was going to go.
No, I was not.
It is
because
normal
if you
in a trial.
you can't
to call
put the people
witnesses
you can't
out
put the
of
people
order
in a
based on
specific
their
spot for me,
availability.
Your Honor. Come on now.
That it is.
That's a rush to judgment.
There's no rush to judgment here. You
Did
keep
the state
saying
did the
that,
state
sir,
have to
but
put
that's
their
not the
witnesses?
case.
Your Honor, with all due respect, did the state have to put their witnesses in order and tell me?
It's irrelevant what the state did.
Did they have to do that?
They didn't need your assistance to do that.
Did they have to do it?
No, they did not.
I didn't have to be
do it.
provided with. We're going to call this witness at this time,
But they're
and this
able
witness at this
to
time.
contact
They
their
didn't have to do that, so why should I have to
and
do that?
accommodate their schedules. This is not about you. It's not about the state. It's about the witnesses'
It's about what's fair.
availability.
It's about what's fair.
No, frankly, sir, it's about you trying to control what's happening in this court.
How am I controlling what's happening? I'm the one shackled to the table with
So
a
here's the
with a
situation.
shock device
It is
on my ankles.
9:52.
So how's I'm trying to control anything?
I'm
I
having
just
to-
want this
I'm
to be
going
fair,
to-
and it hasn't been fair.
Mr. Brooks, it's fair.
No, it's not. If I have to do something that they don't have to do, how's that fair?
It's fair.
Explain to
because
me how
of
that's
the
fair.
process that has been set up to frankly help you. get
No,
the
it's not
witnesses
helping me by
to
it's helping
court.
the state
And no.
by being able to say if we know the time and we know
You
the
did
person
not-
and
I
we know this,
asked you-
then we can be prepared. So we'll already be ready.
Mr. Brooks,
That was
I
the
asked
whole
you
aim of that.
yesterday, and I would have had her come in later. You didn't want to answer that question.
There was no
And
question. There was no question to answer.
That's not
I
true.
did what you asked me to do, Your Honor. You
No, you
said
didn't.
yes, you did. You did. You asked me to give them my witness
Mr.
list.
Brooks,
I gave them my witness list. It's not my fault. It's not my fault they weren't going to be prepared to
Mr.
do
Brooks,
their
here's the
to
deal.
do
The
their
jury's
cross.
coming out, and I'm going to stand my ground on this.
I'm going to
Okay?
stand my
It
ground
is-
too, but I'm
if
not
you
going. I'm not
don't
going to
call
be
her-
disrespectful or disruptive.
If you
I'm just
don't
stating I
call
want it to be
her
fair.
When the jury comes back out, I'm releasing her from the subpoena.
You can't do that.
For your
Where's
lack
the
of
lawful law?
cooperation.
Where's the lawful law? I have the right to
You
witnesses.
have to cooperate with this process.
But I
sir.
also have the Sixth Amendment right.
We have a witness available for you to call. I can require
It's
you
not
to
the
call
witness
her
that
right
should have
now.
been called at this time, Your Honor.
It is based on the list that you provided and
That didn't
in
have
the
a
order.
time. That didn't have a time or of
I'm not going to
or an
play
order.
this game with you, sir.
It's not no game.
It
That's what
was-
you don't
it
seem
is
to
a game
understand.
you. I believe that fully.
I don't care what you believe fully.
All right.
It's not a game.
We.
I don't take
I
this
asked
as a
you-
game. That's what. That's
me
what
explain
nobody.
this to you
That's what
once
nobody.
again.
You don't got to explain nothing to me.
Do you want?
That's what you don't understand. You think
you
that
want
this
the
is a whole
opportunity
game
to
to me.
question?
This is not a game to me, Your Honor. Nothing about this is a joke.
I never
That's
said
what
it
y'all
was a
don't
joke.
understand.
But there's
And it's
some things in
unfair.
the ship
It's
that's going
unfair
on.
and it's disrespectful to me that you think I would come in here purposely and treat this like a joke or a game.
I never said it was a
What
joke.
type of statement is that?
Mr.
Your life is not on the line. Mine is. And you think that I think this is funny?
I don't think it's funny whatsoever.
So,
And I
so I
understand.
think, Your Honor, with all due respect, I think you
So
should show
we're
some
going to take
respect.
a 5-minute break, and when we come back, the jury's coming out, and you need to call your next witness. Thank you. We are in recess.
Nah, you're not rushing me to judgment. I don't care what you're talking about.
While interviewing his ex-girlfriend, Erica Patterson. Poor thing. This poor thing, too. Brooks pulls out 2 pictures of a baby and holds them up. I don't know who the baby is, only because the child they have together is older. She's the teenager. So I'm not sure who the baby is. Nevertheless, this was never shown to the state, and you can't do that. But it's what happens after this that's most shocking.
So that would mean, assuming that would mean no contact at all via phone or anything like that.
No.
So my question would be, I don't know if you can see them from here, but do you recognize these pictures?
You need to show those to the state. The bailiff will take them. That's not proper procedure, sir.
I'm going to object to those being shown to the witness. They have no relevance whatsoever to this trial.
Yes, they do. And I'm getting to how they have relevance.
They've also never been disclosed to the state before this moment.
Sustained.
Sustained why?
Not relevant.
They are relevant. It creates foundation. And I can prove that.
I'll take up the issue outside the presence of the jury at the conclusion of this witness, and if need be, bring the witness back in. But next question, please.
And these need to be offered into evidence as well. You stated that there's been no contact. How would the alleged defendant obtain photographs from you if there's been no contact?
Objection.
Grounds.
Assumes fact, not in evidence.
Grounds.
Sustained. Assumes facts not in evidence. Not relevant.
How's it not relevant? Photos just don't pop up out of the blue.
Mr. Brooks assumes facts not in evidence.
No,
And at
facts.
this point,
I got the pictures
conduct
right here.
after
Facts.
the alleged date of violation here is not relevant.
Have you, since the evening of November 21st of 2021, have you attempted to contact the alleged defendant?
Objection.
Grounds.
Relevance.
Grounds.
I'm going to excuse the jury. All right, sir, I'm going to let you make an offer of proof as to why you believe the photographs and the questioning about contact after the alleged incident is relevant.
It's relevant because these were sent by the witness.
It assumes a fact not in evidence, but
You
what
want
is...
the letter
hold
too?
Hold on. Tell me the basis you believe there's been communication and why you believe it's relevant to her testimony.
It's relevant because it was testified to her first time testifying, and then also by what's the last guy, Guth, that he was told that the witness was supposed to be so deeply afraid of me and all this type of stuff. So if you're so deeply afraid and worried about somebody and this and that, why would you sneak and have
Do you want
contact?
to open up the door to the other act's evidence of
That's
you
not
use-
opening.
No.
That's not
Hear me
opening the
out.
door.
Hear me out. Oh, yes, it does.
No, it doesn't.
These witnesses have been incredibly careful to abide by my rulings. But if you keep questioning her about whether she's afraid or not, or
I
why
didn't
she wouldn't
question
have
her about that.
contact or
I
not,
didn't
you are
question her about
opening
that.
the door to that testimony. All of
How-
my
how
rulings
does-
have
how
been
does-
made to prevent
how
what
does
could be
pictures
seen
work?
as prejudicial evidence. The standard's not prejudicial. The standard's whether it's unfairly prejudicial.
It's
But you
unfairly
can
presidential.
open the door
Your
to
Honor,
that, sir.
I just want to state for the record, Your Honor, that's kind of biased because the state did the same thing yesterday with creating an exhibit right on the fly that didn't even exist that I didn't have. But
That's
then,
not true. That's a
no,
misstatement of the
that
evidence.
is true.
No.
She said it herself.
No. Marking an exhibit is not creating an
No,
exhibit.
not marking an exhibit. She said
We're
that
not going to go
essentially-
down a tangent, sir.
All right,
I'm going
I'm
to
not gonna
focus
argue
on
with
this,
you,
and I'm
but
going to
it's
give
not
you the
fair.
opportunity
It's not
to make
fair.
a record.
It's not
All right?
fair. It's not fair.
When did you receive this document that you claim was sent by this witness?
It's not claimed. It's for a fact.
Sir, it hasn't been established yet. I need to make a record.
So do y'all want
I
the
want
letter?
to see
Y'all want
the letter.
envelope? What?
I want to see the letter.
Okay, so I got.
And I wanna know when you received it.
I gotta bring that in. Every time, this is what I don't get. Every time I'm presenting something that needs to be made for the record and placed in the evidence, it's a problem. But the state can do it, no problem.
It's not, sir. There are proper procedures, and I
Okay,
want
well,
you to
that
make
was the
a
proper
record.
procedure.
If you don't make a record,
So
then
what?
I can't make a ruling.
It threw people off a loop. They weren't ready for it. They scared of it. That's what it is. Come on, man.
Mr. Brooks.
Come on, man. Stop.
When you
Stop
aren't
it.
even
Stop it.
letting
You're a
me
public
ask the
servant, Your Honor.
questions.
I respect your courtroom. I
You
respect
do.
you. You're a public servant, though. Your job is to be the referee. Is it or is it not? You stated so yourself on record that your job is being the umpire.
Your Honor, can I ask Ms. Patterson please be excused?
Yes, you can be excused. My apologies.
My apologies too, but it needs to be some truth. Especially when we're talking about stuff that didn't even happen, but they're allowed to get on the stand and say that it happened when they know it didn't happen.
So I'm going to make a record about what
This
he's
is
referring
ridiculous,
to
man.
in count 77. Okay.
And what happened to that paper? Because it was on the table. Then when I
Mr.
come
Brooks,
back in,
I
it's
need to
nowhere
make
be
a
found.
record of a variety of
So
things.
who took my paper?
And you keep interrupting me repeatedly today. I have shown an abundance of patience this morning. I've warned you repeatedly about being removed from the courtroom. And then every time I try to get into it, you, meaning an explanation and make a record, you interrupt, you attempt to divert everyone from what is being done this very second.
I didn't attempt to do anything.
Yes, you do it repeatedly,
Okay,
sir.
whatever.
So you're doing it once again.
Whatever. Just make your record.
The document that Mr. Brooks wanted to show Detective Guth and this witness was a letter sent from the state of Wisconsin to the court regarding count 77. The state sought to dismiss that count, and they have prosecutorial discretion, and I granted the request that the charge be dismissed.
Why was the charge dismissed?
And that's, I can't answer. It was dismissed because the request was made, sir. They don't need a reason. There's an abundance of case law about prosecutorial discretion. And they chose not to pursue that. My guess
Your Honor,
is maybe
with
to
all respect-
simplify things and to keep this tidy. I don't know. You know what? I'll indulge you. Attorney Opper, would you like to provide a basis for why the state sought dismissal of that charge prior to the start of this trial?
Yes, Your Honor, because as Ms. Patterson just testified a short while ago, she did not have any visible marks or injuries from that event. And we did have the photographs of her injuries. We did not want to confuse the record as to whether or not there was a battery that occurred on November 20th.
Your Honor, I object to that. What does the letter read?
You have the letter. You showed it to me, sir.
And I've been trying to find it ever since I came back in, and now all of a sudden I can't.
And now
find
you're impugning, though, like somehow you're impugning the integrity of this court,
No,
of
I'm
the
not.
bailiffs of this state. You're accusing, frankly, everyone
Did I
of
point
moving
the
your
finger?
papers.
Did I point the finger at anyone? Did I say anyone did anything?
Not directly, but indirectly you did,
So
sir.
how can you make the assumption that I'm saying?
Can
that
I
I'm
please
pointing to
make the
someone?
record without
Yes,
you interrupting
yes, you may.
me?
Yes, you may. I apologize.
I appreciate that. Thank you. But you made repeated comments, sir, about I can't find my documents, I don't know what happened, things of that nature. When you came back out, you took multiple minutes before you even asked your first question of Ms. Patterson. And if I need to, I'll have a bailiff put on the record that no one touched your table.
Anyone touched my table? I didn't
You
say
implied it, sir.
But did I say that?
You stated it implicitly.
I never asked the bailiffs, hey, did any one of you touch my table? I never said that to them. I just said I can't find my paper, which is the truth.
And the way that you said it, like,
I didn't point anyone out, though.
And like, well, that's kind of interesting. I don't have a document that was just on my table. That is what you said.
That's what I said, but I did not point the finger at anyone.
So,
I can
you
see
have
if
the
I
letter.
came in, Your Honor, with
You've
all
been
respect,
given.
I can see if I came in and said, hey, one of you moved something off my table, or if I would have directed that towards the state, or if I would have directed that towards the clerks or something like that, then that would be more of a validity to what you're saying.
It's very apparent to me, sir, that every time, I can't say every time because that would be an absolute, but many times throughout this trial, and especially the last 2 days, when the court makes a ruling that you disagree with, or I want to make a record about some behavior of yours, or a further record about a ruling that you that was not in your favor, that you start peppering me with questions or comments, statements. You question me about the law. You ask, is it verified law? It is, from my perspective, a clear attempt to kind of turn us in a direction away from what we're doing, perhaps even to stall and to delay.
I'm sorry.
That's
you
my
feel that way.
that I'm making a rule. You're doing it again.
I mean, because it has no validity.
Now we have you claiming that there's some document that was sent by the witness after the charges were filed that apparently contained photographs. And you can clarify the record momentarily when I'm done, that you believe goes to the credibility of this witness. So I need to ask a few questions about that, sir, to determine whether it has relevance to those issues. Number one, when did you receive this letter?
I received this multiple letters, actually, over a period of time. It wasn't, I referred to this one because this one had the pictures. But
and why do you believe it was from Ms. Patterson?
To answer your question with clarity.
Thank you. Does it have a date on it, the letter?
No, I didn't bring the letter. I brought the pictures. Because I thought, from my interpretation, I thought showing the pictures would be okay. How did I get these? So my mind was saying, show the pictures. They didn't come out of thin air. The witness knows that they sent me the pictures. They know that.
Well, again, it assumes facts that aren't here. You're assuming this witness sent it. I don't know. But even if she did, what relevance does it have to her credibility before this jury?
It goes to the credibility because she's put on this facade of being so afraid of someone, but yet still, you know that we're not supposed to have contact, but you still sneaking behind and saying, oh, I wonder how you're doing, and oh, this and this and that. Oh,
I don't think she's ever said she was afraid. I think that was the officers who may have stated that, but I don't believe she ever said that. She specifically said today, when you asked her why did you, it was either why did you go back or why did you have, I'll look at my notes, and she said, I don't know.
It was why weren't you forthright with all the details? That was the question.
So again, I'm going to ask you, even if this letter's from her, these pictures are from her, how does it relate to her credibility before the jury?
Who else could these pictures be from?
I'm going to ask you point blank. Did you get a letter that's signed from her?
I got. What do you mean signed? No
How do you
signs
know?
letters.
What's your why do you have a belief that they are from her?
I have multiple letters from her.
You're not answering my question. Why do you believe the letters are from Erica Patterson?
Because they were sent from Erica Patterson. Why else would I?
Were they signed by her?
What do you mean signed?
Did she write her name on the letter? Was it the content of the letter? No, I'm not kidding you. I need to make a record, sir. You're making a statement that these letters are from her and that they're relevant to her credibility.
Your Honor, I'm going to go out on a limb here.
And I'm asking you why you hold that opinion.
I'm going to go out on a limb here and assume, which I know is true, you've never been in my position. You've never been in jail. So you've never received a letter from someone writing someone in jail. no one is gonna. When you
You're
say
not
to me,
answering my
when
question,
you say to
sir.
me,
What's the basis why you believe they're from Miss Patterson? Is there some information in them that only she would know? Did she sign the letters? Is it penmanship that you recognize? Why do you believe they're from her as opposed to somebody else sending you information? Could be your mom, could be, I'm just saying, could be anybody else. You got to answer my question. It's called an offer of proof.
But you still got to understand why this is mind-boggling to me. Like, how I got a child with this woman. Why would I not know her handwriting?
But you have to lay a foundation for these letters, sir. That might be through your own testimony. So that I'm trying to figure out why you believe they're from her. Not all this other stuff about I'm in jail and I have a child. I'm trying to I need to know. It's called an offer of proof.
Are you serious?
What do you believe? Why do you believe they're from her? I am serious.
Because they're from her.
But you're assuming.
Like, how else am I supposed to answer that?
I've given you a few reasons why it would lend to that opinion.
So it has to be put in a legal term.
The bottom line is I need the letter. So if you're going to question her on that, the state absolutely has a right to see the letter. So you need to provide that letter. The bottom line is I'm not going to allow any questioning without having that letter. So the state has the ability to question you about that, or question this witness, and to look at the veracity of what your claims are here. So I may take an early lunch. If that's in your cell, then you can go get it and bring it. But without that letter, I'm not allowing this line of questioning. Do you have the letter with you in court?
I just said no. How many times I got to say the same thing on record?
You know, sometimes, sir, I don't hear what you say because you interrupt me so much or you answer quietly. And I'm taking notes and I'm focused on probably a dozen things at the same time.
But if I say something under my breath, everybody seems to hear it. Everybody seems to hear
that just fine. In a quiet courtroom, yes, we can hear it very clearly.
Everybody assumes that it has to be disparaging.
Once again, you're doing this tactic.
Because
it's
not a tactic, it's facts.
What we're talking
it's
about
facts.
To some other reason.
It's facts. Because I find it hard to believe that all of a sudden nobody hears what I say.
I'm going to let the state make a record of why they believe it's objectionable, because I haven't let them do that. I've given you multiple opportunities to tell me why you believe it's...
I didn't get these pictures from nobody else. Why was somebody else...
The record will reflect you have 2 pictures that you believe were from this witness.
That I know is from...
No, that you believe.
That I know.
All right. I'll ask the state their position on all of this.
My position, Your Honor, is that these pictures, first of all, should not be admissible. 1, because of a discovery violation. We've never seen them before. 2, because we have reason to believe that he did not get them from Erica Patterson. He is on a jail phone call talking to his mother, Dawn Woods, about Dawn Woods sending these photographs to him. Now,
wow. Shit. That's a lie. I object to that.
Let the state make their argument without interruption, sir.
That's a lie, though.
3, I believe that these photographs are designed to make a suggestion to the jury that Erica Patterson is a bad mom. I think that is what the defendant is trying to do. And if we're going to go down that road, then we would be forced to counter that claim. First of all, it doesn't make her an incredible witness, if it's even true. And second of all, if we go down that road, we would be forced to counter that claim by pointing out that not only does the defendant not live with the child in question, he doesn't live with any of the other children that he has. He impregnated Erica Patterson when she was a minor in Nevada, and for doing so, he was convicted of pled guilty in March of 2007 to that felony offense and is on the registry as a result. So if there's any causation that would lead to Erica Patterson being a bad mom, Mr. Brooks has a direct role in that causation.
And that's
furthermore,
I object to that.
I'm not
because that's a lie.
Let him
because at
finish.
the end of the day,
Let him finish.
If we're gonna open the door on that, no, since he want to make a record and not be accurate, so let's be accurate all on the record. Since you think you know so much.
Once
so
again,
we can
Mr.
open the
Brooks
door
is
on.
being
We can
loud,
open the door on how old she told me she was when we met.
interrupting.
We can ask that question
he is
too. Then
over the
did you
top,
ask
animated
that? Did
right
you know
now.
that?
Mr. Brooks, I'm ordering you to sit down and to let the state
No,
finish.
no, I'm not going to sit here and let somebody be inaccurate on the record and lie on the record.
Right. Under Illinois versus Allen, I've warned him repeatedly. He's being removed from the courtroom. And you know what? Let me dial that back. We're just going to take an early lunch, 1 hour. We'll be back. And unless he brings that letter and he can show it is inadmissible, she will not be questioned. And under 906.11, I will declare the cross-examination closed. Thank you. We're in recess. 1 hour.
Get your facts straight. So let's open the door on all of it then, so we can get all of it on the record. Since you think you know so much. Did you know she said she was 18 when I met her? Did you know that? Were you injured the evening of the incident?
Yes.
You were injured?
Yes, I was.
Any reason why that's not reported?
Probably because I didn't tell anyone else.
If you were injured, why not tell anyone?
Because I haven't wanted to talk about the traumatic experience that I went through for still reliving the weeks and days after the incident.
It doesn't make any sense. You talked to FBI agents a few days, or you said you didn't. To be fair, you said you didn't know. You said it was that week, is what you said. The same week. You spoke with FBI agents, reported no injuries.
They didn't ask me about injuries.
Well, would it be fair to say that kind of information would come up when talking to law enforcement, seeing as how you yourself work in law enforcement? It just seems odd, don't you think?
I do not. I was not physically injured.
Oh. Did you file any claims related to the incident?
No, I did not.
So is today your first time bringing up your alleged injury?
No, it is not.
At some point, you were subpoenaed by the district attorney's office to testify here to testify in this trial. Would that be fair to say?
Yes, it is.
Do you recall when you received that subpoena?
From the district attorney's office, it was in July.
Working in law enforcement for 16 years, I'm sure this isn't your first time being involved in a trial. Would that be fair to say?
I have not been in a trial for law enforcement. No, I have not.
You've never witnessed a trial, sat at a trial, been in a trial?
I have not.
I want to back up a little bit to the observation of the vehicle the evening of November 21st, 2021. While you observed the vehicle approaching your position, did you see it strike anyone?
I did not see the vehicle strike anyone, no.
From your opinion, observing the vehicle approaching your position, did it appear that the vehicle attempted to strike anyone?
Yes.
And why would you come to that conclusion?
Because I saw an officer have to jump out of the way in order for the...
When it was approaching.
When it was
approaching.
I'm confused.
Hold on, everyone. The question was asked. This witness is going to be allowed to answer the question fully without interruption. Go ahead and answer the question.
Thank you. I misunderstood his question, I guess.
Answer the question that as you understood it.
Yep. So I saw that an officer have to get out of the way, and he was attempting to stop Mr. Brooks from driving through the parade, and he was at the last minute jumped out of the way from the vehicle. Otherwise, he would have been struck.
You just used the name Mr. Brooks for the first time that you've been testifying. Would that be fair to say?
I don't understand your question.
You just used the name, Mr. Brooks, for the first time since you've been testifying. Is that fair to say?
That's fair to say, yes.
Why haven't you used that name before? You've been up there for quite some time.
I didn't need to.
So what changed for the last question that you needed to?
I don't understand your question.
You just stated that you didn't mention the name before because you didn't need to. So what about the last question that you answered made you feel like you needed to use the name for that question and no question before that?
I don't know.
Come to the knowledge of that name.
It was on the subpoena I received last week.
You just stated a little bit earlier in testimony that you received your subpoena in July. Now you said last week.
Up because this could get hairy.
Those are both correct.
So you received 2 separate subpoenas?
Correct.
What was the difference between the 2?
One was from the district attorney's office and one was from you.
When you were subpoenaed in July by the district attorney's office, the subpoena didn't contain information to the case you were being subpoenaed for?
Objection, relevance.
Grounds.
Sustained. You don't have to answer that. I sustained the objection on that. Those grounds. Ask the question I believe that you're trying to ask, not that one.
Was the name that you mentioned, Mr. Brooks, anywhere on the subpoena that you received from the district attorney's office in July?
Objection, relevance.
Grounds.
Sustained.
Grounds for the sustained. That
Not
was
relevant.
What? Mind-boggling. Sir, in July when you received your subpoena from the district attorney's office, were you even aware what you were being subpoenaed for?
Objection, relevance.
Grounds.
Sustained. Not relevant.
She's testifying in the trial and it's not relevant that she got subpoenaed?
Mr. Brooks, she's here under your subpoena.
What?
You called her as a witness.
The subpoena is relevant because she
Mr.
was
Brooks,
already
under
subpoenaed.
90611, please ask the witness a
This is
relevant and
mind-boggling.
probative question.
This is mind-boggling. Mind-boggling. So were you aware that it was a chance you would be possibly testifying in this trial?
Yes.
And did you know who the trial was for?
Objection,
Grounds.
Sustained.
Grounds for the
relevant.
sustained.
It's not relevant.
I've never heard of nobody testifying in a trial that they didn't know who the trial was for.
Mr.
think
Brooks,
that's- I think
I'm
that's very
sustaining the
relevant.
objection under 90611, and I'm asking you to move on.
Y'all, this ridiculous, man. Seems to me like a like a lot of your answers are coached. Is that fair to say?
Damn!
No.
So the subpoena that you got last week, is that how you learned the name that you used?
Objection,
Grounds.
relevance for the same reason I argued before.
Grounds.
Asked and answered. She's indicated the answer already. 90611, sir. Next question.
The question
Different
was,
topic.
is that the first time that she saw the name?
It's not relevant.
That
Next
was not
question.
asked and answered. That was not asked nor answered.
Under 90611, please ask a question, sir.
Man, what is y'all people trying to pull, man? This is ridiculous.
Mr. Brooks, if you don't ask another question that's relevant and probative under 90611, then I will turn the witness over to the state for their cross-examination.
And then I should be able to get redirect, right?
question, or I will declare the examination by you to be ended.
It's not an examination, it's direct.
It's a direct examination, sir. Under 906.11, you are directed to ask a question, or I will ask the state if they have any questions.
I heard you.
Thank you. Next question, please.
You know who the plaintiff is in this matter?
Yes.
Who's the plaintiff?
The state of Wisconsin.
Is that an entity or a living human being?
Objection.
Grounds.
Not relevant, sustained. Next question.
Have you ever had any interaction with the plaintiff?
Objection. Vague.
Sustained.
Vague.
As to the form of the question.
Have you ever had any interaction with the state of Wisconsin?
Do not answer that question. Next question, sir. Under 906.11.
Was there an objection or was that just a ruling? I'm not sure. You're both was talking at the same time.
For 906.11, I directed the witness not to answer that irrelevant question. Ask your next question, sir. Mr. Brooks, ask your next question.
I'm going to get to it.
Thank you.
So when did you first report your alleged injury?
You do not have to answer that question. Next question, sir.
Grounds for
906.11, sub 1, sub A, sub B, and sub C.
Is that lawful law?
All right, you may sit down. Does the state have any questions for this witness?
Ma'am, that day on November 21st of last year, you were there with 2 kids?
I was, yes.
What were their ages on that date?
Objection.
3
relevancy.
and
Overruled, the witness may answer.
Of course it's going to be overruled.
3 and 6.
Mr. Brooks, please sit down. Mr. Brooks, you're not asking the questions.
I'm not saying
I would
anything.
ask you to sit down, please. It is disrespectful to this witness and to the state and to the court.
No, it's not. Not doing anything wrong. I'm merely standing here.
Okay, let me stop and say this. Because the more I sat through the hours and hours and hours and hours of this trial, the more heartbroken I became for the families of these victims. Truly, in all honesty. This entire thing was made into a complete spectacle at the hands of Darrell Brooks, when it was only meant to give the families of these victims some sort of justice. And it's just not fair to them. It's just not fair to them. I know that it's his right to act as his own attorney, but I guess my question is, at what point do you lose that right? At what point do you lose that privilege? Do you ever lose it? Do you never lose it? Why isn't there a attorney on standby that's sitting through the entire trial so that when shit like this happens, they just pull the privilege from you and the backup attorney comes in and takes over? Like, you're just not capable of doing this. So does that happen? I guess that never happens. Why isn't that at the court's discretion to just cut it off? Like, enough is enough. I have questions. I need answers, people. Help me, please.
Mr. Brooks, I need to give you some advisements, and I'd ask that you stop interrupting me.
I don't need your advice.
I have to give you advisements, sir, regarding your right to testify.
I need to do your job without prejudice and without
Mr.
bias.
Brooks has
Your
now
Honor.
interrupted me multiple times. He's failing to respect the court's oral rulings here today. It's something that he's done repeatedly throughout this trial. Mr. Brooks, I need to go through some advisements. Unless you have a witness to immediately call, I need to go through this particular discussion on the record with you regarding your right to testify.
You don't need
Do you
to
have
go
a
through-
witness
you
to
don't
call,
need to go
sir?
through anything with me on record. You
Actually,
need to-
I do so,
Actually,
sir.
you
That is
don't.
required by
Actually,
law.
you don't. You need to do your job as a public servant,
Mr. Brooks,
and honor the oath that you
I
took.
need to
Your
go
Honor.
through these advisements, and if you're going to keep interrupting me, you will forfeit your right to be present, and you
So
will be
you're holding me in
removed
contempt
to
again.
the next courtroom so that I can properly go through these advisements without being interrupted.
And I still don't have to answer. I still don't have to answer whether I'm in this court or not. So you're holding me in contempt yet again.
Mr. Brooks, I've not held you in contempt. I've found that you have forfeited your right to be present by your conduct, which is one of the options available to this court. Mr. Brooks, you are advised that continued interruptions will result in you forfeiting your right to be present during this next phase of the trial.
Okay, but you saying that
I've
forfeiting
said that
my
multiple
right.
times.
You
I've
saying-
given you multiple opportunities
You're
to
holding
stop
me in
interrupting
contempt.
me.
You're holding me in contempt.
Mr. Brooks,
By
I'm not holding
removing
you
me
in
from the
contempt for
courtroom.
the second time here, and I've
Your
also
Honor.
repeated that.
Your Honor,
He's
with all-
interrupting me yet again.
with all
Mr. Brooks, I
respect-
need you to stop talking.
With all respect, in Illinois versus Allen.
All right, Mr. Brooks continues to want to debate with me the meaning of Illinois versus Allen. It is a clear indication to this court
trying to
that
understand,
he
Your Honor.
wants to disrupt these proceedings, even
That's
in
not
a
true.
mild manner tone
That's
of
not
voice.
true.
I've
I'm
reminded
seeking
him
to
repeatedly
understand, Your
regarding
Honor,
the standards
because
of
it
decorum and
doesn't.
civility, and one of the
Illinois doesn't.
bedrocks is that he
Illinois
not
versus
interrupt.
Allen does not state.
All right, I'm going to
that
remove him to the next courtroom so that I can go through
It does
proper
not state-
advisements with him without being
It
interrupted.
does not
We'll clear
state
the courtroom
that
and
you
we'll
can be
resume
present from
once he
cameras.
is over there. Again, I'll
It
make
doesn't
the
state that
appropriate
you can be
findings when
present
he is
from
there.
cameras, or that you could be.
Yes, we're off the record.
Or that you
until,
could be.
he's in the
Okay,
other
so
courtroom. I'll
you're
be
making a
stepping off.
tacit agreement for something that I.
All right, thank you. I do have verification. There are headphones on the table in front of Mr. Brooks should he choose to wear them. I see he's reading from a book at the moment. Just this morning alone, about 26, 27 different times he interrupted me or spoke over me. Once I made a decision on his motion to dismiss and his request to recall a witness, he then asked if for written findings. I denied that. He then asked for what law I was following. I indicated I wouldn't explain that further, that I already made an oral ruling. He asked for a stay. He asked for dismissal. All of those things I either denied or said I wouldn't answer, specifically as it relates to the request for an interlocutory appeal. So Mr. Brooks has, by his conduct, forfeited his right to be present on a number of occasions due to his conduct. I do appreciate that this morning he didn't yell at me, he didn't raise his voice, he didn't speak in an angry tone. But given the history in this case leading up to today and knowing what this court needs to get through in terms of whether he has any witnesses or whether he intends to testify himself, there's a very important colloquy I need to have and an advisement of his rights that I need to go through, and I simply am not able to do that with him constantly interrupting me and then not respecting the oral rulings that are made. Of course, at any point in time, Mr. Brooks can ask to be brought back over to this courtroom. Question previously, other than you potentially testifying on your behalf, do you have any other witnesses present at the courtroom, at the courthouse to call today? I need an answer to that question, sir.
So we addressing subject matter jurisdiction. topic that we haven't addressed when I was just over there, or since I've been over here? Are we addressing subject matter jurisdiction?
I'm going to mute him just for a second. No, I'm not going to address subject matter jurisdiction. This is a common ploy by Mr. Brooks. When I attempt to go through certain things with him, ask him questions, he tries to divert our attention away to subject matter jurisdiction. Do you have any other witnesses other than yourself available at the courthouse to call this morning, meaning now?
This is the jurisdictional challenge right here. So are you going to address subject matter jurisdiction and prove it for the record or not?
So I've asked Mr. Brooks twice now whether he has any witnesses to call other than himself. He has declined to answer that question. Sir, if you fail to answer that question, I will interpret your failure to answer that as a no, and you will lose the opportunity, you will forfeit the opportunity to call any other witnesses on your behalf other than yourself. So I will ask you one last time, sir, do you have any other witnesses at the courthouse available to testify right now? I'm not getting a response at all.
Am I unmuted?
You've been unmuted, sir.
You just said I was muted, so I'm not sure. I don't know when you muted me or when I'm not muted.
Well, me muting you doesn't affect you being able to hear the court because
Yes, it does.
that only
Yes, it does.
mutes your audio coming into this courtroom. I confirmed already
Why is my
that
audio muted to begin with?
that is simply a misstatement. I confirmed with the bailiffs that the audio and visual were working.
Why is my audio muted to begin with?
Because you interrupt the court repeatedly. So I'm going to ask you yet another way, even though for 3 times now he has failed to answer this court. You indicated last week that you would like to call your mom as a witness, Dawn Woods. You were provided with notice that the state would not be assisting with that in any way. You indicated when that was said that if you wanted your mom to testify, she would obey you and she would be here. So I trust that you've made arrangements for her to be here. Are you going to call Dawn Woods as a witness this morning and specifically now? I will ask him a second time. Sir, do you have Dawn Woods available to call as a witness this morning? Is Dawn Woods in the courthouse available to testify right now? Do you intend to call her?
Hold on.
Mr. Brooks's statements that the audio doesn't work when I mute him is simply false.
I didn't say nothing about the audio not working, so you need to stop lying on the record.
I'm not lying on the record, sir.
You are lying on the record.
All right, I'm going to mute him once again because now he's raising his voice. Now he's angry. He's thrown the headphones. He certainly does not seem to want to answer any of the questions this court has. I asked him 3 times if he had any additional witnesses to call. I warned him that if he did not answer that question, he would forfeit his right to call additional witnesses other than perhaps himself. I then specifically asked him about Dawn Woods because that is the person he indicated he wanted to add to his witness list last week, and I granted his request to do that. I asked him twice. He did not respond to that. Based upon his failure to respond, based upon this court advising him that if he failed to answer that question, he would forfeit his right to present any additional witnesses, again, other than perhaps himself. I'll find that he has forfeited his right to present and call any additional witnesses based upon his conduct in this case. Any requests for jury instructions? Or in your review, you think anything needs to be changed, deleted, added, etc.? I know I'd ask that it be put in writing, but I'll also give you this opportunity to verbally advise the court and make your requests. Do you have any requests as it relates to the jury instructions, sir? Box is right in front of where he's seated, so I can't presently see his face. I see his jacket is off, because I can see the outline of his arms, and I can see the jacket on the back of this chair. He is unmuted. I've confirmed previously regarding the audio working, and I will just ask him a second time, sir, do you have any requests as relates to the draft packet of jury instructions, whether that be any additions, corrections, edits, or deletions?
And Your Honor, would it be possible for the bailiffs to just move the boxes off the table so
Yes,
we
I
can
think
see?
that's fair. I'm going to advise the bailiff to remove the box so I can see Mr. Brooks. If you could move the second one because it can interfere with the microphone as well. And the third one. Mr. Brooks, I'm going to ask you for a third time. Do you have any requests as it relates to the jury instructions? Any requests for instructions that aren't included that you believe should be included? Any edits or deletions from the packet that has been provided to you?
Hey, why do you tell them to move my box?
Because I couldn't see you, sir.
Or what?
I've asked you twice now, and I'll ask you a third time. Do you have any requests as it relates to the jury instructions? Any additions, deletions, edits, or otherwise?
Hey, man, you don't got to talk to me like that.
Do you have any requests
First of all,
related
what?
to the jury instructions, sir?
Man, yeah, I got requests. It ain't like they gonna be honored though.
As it relates to the jury instructions, sir, what are your?
I heard what the hell you said.
Very disrespectful.
Yeah, and I've been getting disrespected since the beginning of this whole process. So welcome to the club.
Mr. Brooks, do you have any requests?
I'm tired of my race being trampled on here too. I'm tired of it too.
Do you have any requests as it relates to the jury instructions?
Ain't nobody understand why I'm frustrated. How you gonna sit up there and make decisions based on what you think I said when I didn't get consent for you to do any such thing?
Sir, I understand you may be upset, and I really do, but I've made my determinations.
You don't understand nothing. You don't understand anything, Your Honor. You don't.
I'm going to mute him again because he's not answering the questions that I'm very clearly asking him, and I've given him 5 opportunities. Mr. Brooks, do you have any requests as it relates to the jury instructions? I'll unmute you for that answer.
I can't hear everything you're saying.
Mr. Brooks, I know the audio's turned up. I believe you can hear me. You've chosen not to put the headphones on. That's your choice. My final question to you, do you have any requests as it relates to the jury instructions?
I just told you, am I muted? Am I muted?
No.
I just told you, I don't know how many times, I can't hear everything you're saying.
Then you should put the headphones on.
Don't you understand? What about that don't you understand? If you see headphones, you can see everything. You can see boxes, but then you see headphones.
Have you asked for headphones to be provided, sir?
I shouldn't have to ask for them. I didn't ask for my boxes to be moved.
I believe they took them away previously because you were so agitated they were perhaps afraid you might break them.
Yeah, I'm still agitated. I ain't gonna stop being agitated. That ain't gonna stop. You sit up here and do everything you're doing and think God don't see what you're doing? You ought to be ashamed of yourself.
Mr. Brooks, do you have any requests as it relates to the jury instructions?
Yeah, I can hear what you're saying. I can hear what you're saying.
You just told me you didn't. So which one is it?
Yeah, I got the headphones on. You can't see that?
What are your requests as it relates? What are your requests as it relates to the jury instructions, sir?
Man, don't try to come with this whole little image, sir. Now it's all this, sir, and all this. I'm gonna get where I'm going. Try to put on this little act like you so worried about what's going on with me. You don't give a damn. Never did.
Mr. Brooks, you're being disrespectful again.
You've been being disrespectful. You've been being disrespectful.
I need to know what your position is regarding the jury instructions, and I need to know it now.
What you mean? Who you talking to?
I'm talking to you. I need to know whether you have any requests as it relates to the jury instructions, sir.
Yeah, first of all, why am I charged with 2 bail jumpings when I was already charged in Milwaukee for the same bail jumping? That's double jeopardy.
That's not double jeopardy. Your objection is noted. It's overruled.
It is double jeopardy. How you gonna charge me with the same charge that I'm already charged with? You can't do that. The Fifth Amendment says that you can't place somebody in jeopardy of life and limb. Twice. I'm already charged with the same count in Milwaukee. For the same case. It's the same bail jumping charge. So how am I charged with that here?
Sir, I'm not going to provide a legal explanation other than to say I've reviewed that. Your objection is noted, but the jury will be instructed regarding the bail jumping.
It can't be because that's double jeopardy. Under the law, if two charges are identical in nature, you cannot place me in jeopardy of life and limb twice. You can't do that.
What's your next?
The same case number.
What's your next request, sir? I'm noting your objection.
I'm trying to talk. Can I get it out? You always want me to not interrupt you, but you always find a way to talk over me.
I understand your position. I'm saying it's overruled. What's the next issue?
Either one company gonna charge me with it or y'all, but it can't be both. It's the same. It's pursuant to the same exact thing that I was on bail for. The same exact thing. The same exact case. So why are we giving the jury instructions on 2 cases from another county?
I've made a note of that. What other requests do you have?
Man, this is ridiculous. So I'm not even able to adequately defend myself, present evidence, do anything, because everything I say is going to be found a reason for it not to be valid. What are we doing here, Your Honor? What is the
Mr. Brooks.
Why should I be here when
I've made a note of your request as to count 74. Do you have any other requests as it relates to the jury instructions?
Why are we even having jury instructions? Why do I have to even sit here in this courtroom at this point? Because everything you've been doing without my consent anyway. So you're gonna find a way to do this without my consent. So why do I need to be here for?
Your objection for lack of consent is noted for the record.
Okay, yeah.
Any other requests, sir?
You talk a good game. You talk a good game to save yourself enough space. But everything I put up, it has no merit in your court. None.
All right, I've asked him many times. I've advised him, and I'll advise him once again. If he fails to answer the question, I'm moving on. Do you have any other requests as it relates to the jury instructions, sir?
You can't move on because I haven't given you consent to.
All right, he did not answer. So I'm muting him again. The only request that he has made as it relates to the jury instructions, as he pounded his fist once again, raised his voice. I understand, I really do, that he's upset with my decision to cut off his ability to present a defense, but that decision was made based on his conduct and his conduct alone, as I've outlined already on the record. So the only request that he made was as it relates to the bail jumping counts. I'm denying those requests, whether it be to dismiss one count or to dismiss both on double jeopardy, or to just not instruct the jury. However way I interpret it, I'm denying that.
54 summary of evidence. I believe we had a map, actually 2 maps that summarize the, we had 3 maps. I think the one was summarized his route, the path that he took. The other one summarized the victims who were struck in the specific locations. And the other one summarized the positions of the law enforcement officers at the various intersections and throughout the parade routes.
I'll make a note of that. I don't believe I saw the jury view instruction either. I mean, that was given to them at the time. I don't know that it needs to be reread, but I think we need to consider that as well. And that was my version of 152. All right, so let me go through the list from the state. Turning to page 61. So I've considered the request by the state. I am going to rely on what information they put in the charging document. I'm going to deny the request to include the specific case numbers. There is evidence, of course, that was received regarding the 2 separate cases out of Milwaukee County that form the basis for both of the bail jumping counts. It will be up to the jury to review the evidence and make a determination. As to the verdict forms, though, that were referenced previously, at least the description of them in the jury instructions, that obviously the third account of bail jumping is incorrect. That needs to be battery, and that change will be made. So as it relates to this, the state is asking that I simply instruct the jury based on the pattern instruction and not include that second paragraph. I had previously advised the jury with another paragraph that I was contemplating including, even if I took out that big paragraph that just said, at times Mr. Brooks has appeared from another courtroom. This must not influence your verdict in any manner. What's the state's position on including that but taking out the paragraph you request to be taken out?
That's fine.
Mr. Brooks, do you have any position on that? I need the bailiffs to move the boxes away from his face. I need to be able to see him. He can keep them on the table, but they need to be moved off to the side. And if he does it one more time, then I will instruct the bailiffs to take the boxes away. Those are trial prep materials. If there's something in those materials related to jury instructions, he should take those out now. Otherwise, they need to be moved away from the microphones and away from blocking his face.
I'm not putting them there. I'm not putting them there. She can't see me. I'm putting them there for a reason. I'm gonna let them do with her and they can see.
Mr. Brooks, do you have any position on the verbiage of jury instruction 70 on page 65?
Don't ask me no question. Are you my accuser? Are you my accuser, Your Honor?
All right, he's choosing not to answer, so I'll mute him again. It's unfortunate that he's deciding not to participate in this.
All right, guys, if you're still here, thank you, thank you, thank you. I appreciate you so, so, so very much. Please leave me a like and a comment. Let me know what you thought. Please, if you haven't subscribed yet, please consider doing so. It really helps me out, and I really appreciate it. If you guys have any suggestions, please email me, harding527@yahoo.com. Or you can leave it in the comments. Like I said, I save all your emails. I screenshot all your comments. I promise you that I do that. And until next time, stay safe out there.